May I now request Mr. Ankit Singhi to take us through recent regulatory updates in the LLP law and security law relating to REITs and invites. Over to you, Mr. Ankit Singhi.
Thank you, sir, and good evening to everyone. So I'll start with the regulatory updates, starting with the recent amendments on the LLP front. So recently, MC, after a long time, has come out with a scheme to relax the additional fees that is payable in case of delayed filings of certain forms in respect of LLP. The scheme was, the circular was notified last month, and it relates to 3 forms per se. Form 3, which refers to intimation with respect to changes in LLP agreement. Form 4, for changes in designated partners and partners. And Form 11, the annual return of LLP. All Form 3, Form 4 basically are event-based forms, and that has to be filed within 30 days of the event. And Form 11 is an annual form that is filed every year, similar to annual return that is filed in case of companies, and is filed within 60 days of the close of the financial year, that is 30th May. So I think there may be various reasons for introducing such a scheme. Is firstly maybe on account of the technical reasons. But what I've seen from my experience, that Form 3 is basically an document that needs to be filed generally soon after the incorporation of the LLP, and thereafter when there are changes. And most of the entrepreneurs who form LLP generally are not being made aware of this requirement of filing this form post the incorporation. If you see, most of the pendencies that would be there in the records of the registry of fees under Ministry of Corporate Affairs would prominently arising on course of the requirement or delayed filing, or filing or forms that were filed or that still not filed in case of the event arising on account of incorporation of LLP, and then subsequently if there is any changes in the LLP agreement. Form 4 is with respect to change in partners. 11, it's every year filing that is required. Even those forms there are cases which MCA has found out in its own internal examination that these are also pending for some LLPs over a period of time. And I think to ensure, to give a window to all these LLPs to ensure that they make good all these pending compliances, this specific window has been created from 1st September 2023 up till 30th 11/2023. So for September, October, November, 3 months, this scheme will be there, and it is applicable in case of Form 3, Form 4, Form 11. Form 3, you can file additional form. You can file a Form 3 and 4 without any additional fees during the period of September, October, November, without any additional fees. If the event that is the change either in the partners or either in the LLP agreement is has taken place 1st January 2021. In case that change has taken place on and after 1st January 2021 and you have not filed the relevant form, and then you can use this window to file the form within these 3 months, and you will not be subjected to any additional fees that is otherwise applicable. And in terms of the slab, there are 2 times, 4 times, 10 times, 50 times, 25 times, depending upon the nature of the form. So you can save that kind of additional fees if you choose this scheme to file the form within the window 1st September to 30th 11. Then Form 11, since it is an annual return, as I mentioned, it is related to financial year 2021-2022. So for financial year 2021-2022, 2022-2023, if you have not filed the annual return in Form MGT in Form 11, then you can also use this window to file both the forms during the period 1st September to November. In case of forms which are for period, in case of Form 11 prior to 21-22, or in case of Form 3 or 4 where event date is prior to 1st January 2021, there is also a provision that you can file the form with some additional fees, not in terms of the grade slab that has been outlined under the rules, but you can also pay them on a discounted basis by way of 2 times in case of small LLP and 4 times in case of other than small LLPs of the fees. You can use that medium to also file these forms if are of the period prior to those mentioned in the scheme. So Form 3, Form 4, Form 11 of the specified events and for the financial year covered in the form in the circular, you can file in September, October, November without any additional fees. If they are of a period which is not covered by this circular, then you can also file those forms within this period of September, October, November by paying 2 times or 4 times, which is much lesser than what must be due in case these forms are still pending for filing. And you can use this opportunity to file even those forms by paying a lesser fees as what otherwise you would have paid in case you have filed it without utilizing this scheme, or in case you file it after 30th November 2023. So in that sense, this is a much welcome scheme. I think similar scheme is also required for form related to charges and in case of form related to companies, because on account of version 3 related issues, a lot of companies are still not able to file their forms for one or other reasons which are out of their control. And similarly, in case of charges, because there is no condonation or allowed in case of creation of charge, any delay on account of creation. So there are a lot of charges also, which because of going beyond the prescribed timelines, companies are not able to register those charges and finding it difficult to comply with the provisions. So if similar schemes can also be there for those forms for charges and for other forms which are companies are not able to file on account of various reasons of technical nature and V3, I think that can be also much needed relief, which everybody will be looking forward. I think this can be a starting point, and we may see similar schemes in times to come. Then there was no other change under the Companies Act or LLPs. There was a small change with respect to offer for sale by REITs and InvITs. So in January this year, there was a circular which was issued by SEBI outlining a detailed process to be followed in case of offer for sale for promoters who intend to comply the requirement of minimum public shareholding, because offer for sale is one of the various options that have been laid out to meet the requirement of minimum public shareholding under the relevant provisions of securities contract regulation. So while that circular detailed outlined in detail the process that needs to be followed for coming out with offer for sale, there was a paragraph in that circular which also applies the same set of modalities in case of an offer for sale by sponsors or of a sponsor group, or in case of a real estate REITs or infrastructure REITs, but infrastructure investment trust. But that was only applicable in case of listed REITs or listed InvITs. But as opposed to REITs, which can only list through an IPO. In case of InvITs, there was also an option of a privately listed InvITs. That was not otherwise earlier allowed under the OFS modalities, because it specifically talked about listed REITs and InvITs, which intend to cover listed by way of an IPO. So therefore, in August, there is a amendment to those guidelines, and relevant explanation have been issued with respect to also allowing privately listed InvITs to use this circular for coming out with an offer for sale. Similarly, in case of an offer for sale, in case of privately listed InvITs, retail investors are not allowed to participate. So therefore, necessary explanation has also been issued that so far as that circular provided for the participation of retail investor in the OFS, to that extent, that will not be applicable in case of an OFS by InvITs, because in a privately placed InvITs, retail participation is not allowed. So to that extent, that circular has been modified by way of a subsequent circular issued in last month, which predominantly talked about how OFS as a medium can be used by InvITs who are privately registered, not registered by way of an IPO. So these were the key changes that were there in the offer for sale framework for units of REITs and InvITs. Thank you, and I think Anjali will take care from the other relevant amendments or changes in the securities law.
Thank you, Ankit. Thank you, Ankit. May I now request Anjali Agarwal to take us through the other updates in securities law, and there are, to my mind, quite important circulars. So over to you, Anjali.
Thank you so much, sir. Good afternoon, friends. First of all, just excuse me for not being able to switch on my camera. There is some net issue today, and as a result of which I'm not able to open my camera. Now, as far as the securities laws amendments are concerned, though not many amendments are there, but as Mr. Agarwal said, all the amendments which have been there are very important pieces of legislation and are needed to be adhered to very seriously. First of all is the reduction of timeline for listing of securities. This is important for us, not just as the compliance officers or listed companies, but even if we invest in any of the shares of the listed companies. So in the erstwhile provisions, the listing regime was T+6. T means issue closing date. So within 6 days, the listing was required to be completed. But now the 6 has been reduced to 3, meaning thereby this is a beneficial position not just for the companies but also for the investors. Companies which were raising funds, otherwise the monies were coming to them by T+6 day. And the investors who were investing in the shares, their monies were remaining blocked in ASBA account for almost 7 to 8 days. If somebody invested in the issue opening on the very first day and the allotment or listing was happening on T+6, the shares were coming to his demat account on T+ almost 10th day. So money was remaining blocked for that long. Now by virtue of T+3, the funds would be, in case the shares are not allotted to him, his money would be unblocked within a period of almost 4 to 5 days. So there has been a lot of curtailment in the time frames by SEBI. And secondly, the only people who will really have to work hard in this T+3 regime is the merchant bankers and the registrars, because they have to prepare the basis of allotment. And earlier, which they were doing it within a period of 6 days, now they'll have to do it within a period of 3 days. Now, how the timelines would be: on T+1 day, allotment would be done. Then T+2 funds would be transferred to the people who have not been allotted the shares, and T+3 allotment will happen. So as a result of which, from the company's perspective, there would be faster deployment of funds, and from the investor's perspective, in case they're not being allotted shares, the money would get unblocked faster. And in case they have been allotted shares, they will get faster liquidity by virtue of faster listing. Shivam? So these reduced parameters are presently on the voluntary basis. Up till 30th of November, it's on voluntary basis. But with effect from 1st December 2023, it will be a mandatory provision, and this will have to be mentioned in all the offer documents, in all the prospectuses that will be issued by the companies, and has to be complied mandatorily. Now, facilitation of redressal grievance mechanism. When we talk about the object of SEBI or the purpose why SEBI has been set up, the preamble of SEBI Act says to take care of the investors benefit. So investors, many a times, all the investors have various sorts of complaints. These complaints may be against the company, maybe against the merchant banker, debenture trustee, registrar. So, and under the present norms, if any complaints are received by any of these agencies, the same are needed to be redressed within a period of 30 days. But now this period of 30 days has been reduced to 21 days, thereby expediting the investor grievance mechanism and investor protection. SEBI's prime motto has been investor protection. So that's a very good step in that direction. These amendments, this reduced provision has been made applicable to portfolio managers, investment advisors, research analysts as well. Further, one more thing that SEBI in this circular, in this amendment, has said that they'll designate some body corporates which will be responsible for managing and overseeing the grievance redressal process within the specified timeline. I have to understand, I have to see what sort of body corporates will they be. Will they be private bodies, or it will be a body, it will be some entity created by SEBI? That with time to come, we'll get to know. Now, with regard to an important amendment in the listing regulations, a new chapter 6A has been inserted, providing for the voluntary delisting of non-convertible debt securities or non-convertible preference shares. Under the erstwhile regulations, there was neither in the listing regulations nor in the SEBI delisting of equity shares regulations, nor in the NCS regulations, there was any provision of delisting. About 2-3 months back, SEBI issued a consultation paper in this regard, and with effect from now, it has been made, incorporated that the securities, NCDs or NCPS listed on private placement basis can be delisted, can be voluntarily delisted. There are certain conditions which have been given in the regulations in which scenarios the delisting is not permissible. So one of a few of the exceptions which have been provided in the regulations is, so any company which has come out with a public issue of NCDs or NCRPS, that company cannot be voluntarily delisted. Any company which has more than 200 NCD or NCRPS holders, excluding the QIBs, cannot be voluntarily delisted. Any company wherein any NCDs or NCRPS are being delisted by the exchange as a result of any penalty imposed on the company or any penal action imposed on the company, those cases will not be governed by the process given in the regulations, given in the amendment. And then if any of the NCDs or NCRPS have been redeemed, then these provisions will not be applicable. And if the company goes in under CIRP and pursuant to a resolution plan, any NCDs or NCRPS are being delisted, then also the provisions given in or the process given in will not be applicable. Now, abridged prospectus. These days, we are seeing that many companies are coming out with public issues of NCDs or NCRPS, and any prospectus, be it equity, be it NCDs, runs into at least 300 pages. And I, as an investor, if I want to understand the important aspects of any of the public issues, it's impossible for me to go through those 300 pages and find out as to who is the promoter of the company, as to what are the major terms of the issuance of that particular issuance, what all litigations are going on in the company. So this concept of abridged prospectus, this has been there for equity issuances, but for NCD public issuances, this has now been brought in. And this is a simplified format. And as we speak, BSE in the afternoon itself has issued a simplified format of the abridged prospectus. The format which was given earlier, there were certain loopholes or certain problems were pointed out, and now BSE NSE have issued a simplified format of the same. For issues opening after 1st October 2023, this will be mandatory and has to be given along with the prospectus in every case. And it will contain the broad terms of the issue. I think these were the amendments which have been there in the last month from SEBI's perspective. Over to you, Agarwal sir.
Thank you very much, Anjali. Beautifully covered all the updates, very clearly understandable. Friends, in the last monsoon session of Parliament, a very landmark historic law was enacted. The law was the Digital Personal Data Protection Act 2023. This act has also the bill passed by the Lok Sabha and the Rajya Sabha, and then it has received the assent of the President of India. Now, this is a very landmark legislation. It redefines, business, empowers individuals. It will usher in, to my mind, a new era of, responsible practices and responsible data handling by the businesses. To decipher and to decode this particular act and take us through the nitty-gritties of the act and how it benefits us as a person and how it impacts our business, may I request Mr. Ravi Prakash to take us through this new development. Over to you, Ravi.
Very good evening, sir, and good evening to friends, seniors, and my colleagues who are attending. This Data Protection Act, or Digital Personal Data Protection Act in its full sense, is the fifth version of the proposed Data Protection Bill, or the pieces of legislations that were attempted at making a law for making our nation a trusted data nation. While the act itself is not sizable, the issues and questions arising out of this particular piece of legislation are complex, and they are sizable indeed. Therefore, because it is not a legislation which is made for a personal, for a specific class or a specific niche, it is a piece of legislation which in its true sense is for the common citizenry and for you, me, and all of us. Therefore, it is also important that we understand on what presumptions, on what principles this act operates, and what aspects of businesses and our daily lives this act is going to touch. First of all, the applicability of the act, which is mentioned in section 3 of this legislation. It applies to processing of digital personal data within the territory of India, where the personal data is collected in digital form or in non-digital form and digitized subsequently. So while reading this, you would see what is your personal data. The digital personal data is combination of two words. One, and the key aspect of this connotation is personal data, something or set of information or pieces of information digitized or non-digitized, which will be digitized subsequently, and that piece of information or data is capable of identifying an individual. That is your personal data. For example, Aadhaar is a facet of personal data. Your PAN card, your PAN number, your name along with your father's name, and any piece of data which would personally identify you. It could be series of data, a mix of data, or a single data in itself. As I showed, Aadhaar in itself or PAN in itself can identify you personally, identify an individual. But in combinations, if name, father's name, address, all these combinations are there, then also identification can be done. So in any form, if a piece of data is capable of personally identifying an individual, that is the personal data this legislation seeks to apply on. And digital because in non-digital form, the longevity of collected data is lesser. And in today's age, the entire set of data which is collected is kept in digital form. So therefore, for all practical purposes, any area to regulate would be majorly in the digital space. So therefore, and this will include any data which is collected in physical form and then digitized subsequently. So this Digital Personal Data Protection Act. Now, the Act is premised on the concept of affirmative consent, which means that a data can be collected and processed as provided in this law only by obtaining your consent. And when I refer to you, I refer to data principal from whom the data is to be collected. These data principals would be sharing data with businesses or other entities which has no business or commercial purpose, well, with the government as well, for different purposes and in different walks of life. Data shared with government hospitals, data shared for availing subsidies, data shared with an insurance company, data shared with your broker, and so forth and so on. All these facets where your personal data is collected and further processed would be covered into the ambit of this law. They say that for any such collection or processing, the law prescribes that there must be a consent which is an informed consent, and the facility of consent would be provided in multiple and vernacular languages also. That is also being provisioned under the Act. And of course, as the law of consent works, the consent could only be obtained by true and fair disclosure of the purpose, usage, or collection of the data. A consent which is given for an unlawful purpose or obtained for an unlawful purpose would be no consent. And in any case, it can't be acted upon without violating the law. So for the moment, we are only talking about the legitimate purposes for which the personal digital data can be collected and processed. Before we move forward to discussing details, the collection, processing, usage by the data fiduciaries, let us go to the applicability of this law and understand what is the remit of its applicability. So the law applies within the territory of India and also beyond. If the data is being collected or processed or used for the purposes of any activity or for rendering goods and services within the territory of India. So therefore, the Act has a global application. And as I said in plenary, that since most of the data which is being processed in today's age is in the digital space, you see that the application has been made global because there is a lot of interdependence. Businesses have their servers in overseas locations where the data is collected or is collected from here and then stored and processed there. So all those situations are also sought to be covered by this piece of legislation. Without taking or quoting examples, you would have heard of many telecommunication companies as well as online chatting platforms whose servers are located outside and overseas this country. So therefore, this act seeks to take into its remit all such activities for protection of the personal data. Now, why was the need to bring out such a legislation? Because we have to understand that this legislation is going to increase the cost. If a business has to follow these guidelines or this piece of legislation, they have to put in place several operational as well as technological infrastructure facilities to comply with the law. And so therefore it seeks to protect personal data, but the cost of protection is high. So therefore, why this law was brought, or a need was felt to bring this law at the first place? With the world becoming global, there is always in businesses all around the world with interdependence on each other. Government seeks to protect the right to privacy, which was held in 2017 in K.S. Puttaswamy's case, where the government undertook before the Supreme Court that they would bring a piece of legislation, as it was felt during the course of arguments that the Section 43A of Information Technology Act, which currently is the provision, and the rules made thereunder, are the only provisions which seek to regulate this aspect of world or the society. And therefore it was felt that because future is going towards data, and because the businesses, non-businesses, all, I mean, whether it is for commercial purposes or non-commercial purposes, all these entities, all these commercial world is relying on the digital personal data for their advertising, marketing, their usage, for exploiting the data for, I mean, the usage is secondary, it could be commercial or non-commercial, but you see to cater different portions of society, and I must say collectively the entire world together. This personal data is being relied on by everyone. And so there is a need that the privacy of the individuals are also protected. And we all know that in 2017, when the famous Aadhaar case was being argued before Supreme Court, the various aspects of challenges to privacy were raised. One who wishes to dwell deeper into the challenges of privacy or challenges to privacy, or the recognition of different facets of privacy that were recognized by the Supreme Court in the K.S. Puttaswamy's case, may refer to the judgment or may refer to the eloquent discourses of senior advocate Shyam Diwan, who goes on to explain bit by bit and in seriatim the challenges posed to the privacy of individuals in the modern day. So therefore, this was the main aim, that because it is right to privacy is a fundamental right enshrined in the Constitution of India, the government must bring a legislation to protect that. And as I said, this is the 5th in series now to be implemented, as it has passed both the houses and also published in official gazette last month. So therefore, it is now to be implemented, but the legislation, if you compare it with the global counterparts, GDPR, the GDPR guidelines, which applies to entire or substantial part of Europe, you would find stark difference between two different legislations. The Indian counterpart does not distinguish or does not categorize data into different sensitivities. Although on a deeper reading of this legislation, one would find that the penalties, which are in itself very high and deterrent enough, if the law is properly enforced, the highest of penalty runs up to 250 crores and then to 200 crore. And there is a whole set of penalties that is given. It starts from 250 crore, failure to take security measures to prevent data breaches. If there is a failure of data fiduciaries, which could be business entities or government or non-government organizations, 200 crores non-fulfillment of obligations to processing of children's data, it's 200 crore, breach in observance of a significant data fiduciaries obligation, 150 crore. And there's also a penalty on individuals up to 10,000 if they do not fulfill their duties, which is not to impersonate in the process of data collection or processing, or if a frivolous complaint is filed. These are the penal measures which are provided in the law to safeguard the abuse of law from both the ends. As I was mentioning, the GDPR legislation is starkly different from the Indian piece of legislation in terms of the categorization that GDPR offers for different data or different data types. But if one reads the penal provisions which are provided in this law, those penal provisions does distinguish or does lay down the factors for deciding the quantum of penalties. And while for decision on the quantum of penalties, various factors are given where one may find that that the sensitivities of different data breaches must be taken into account, because imposition of penalty would be at least a quasi-judicial exercise by the board which would be created under this legislation. And therefore, in that sense, on the enforcement side of it, given the texture of and the fabric of the very fabric of our punitive system and the principles inherent to it, one may say that even though no hard and fast categorizations are given in the law itself regarding the data, as in GDPR, but the penal provisions do recognize the distinction.
Ravi, unmute yourselves.
Am I audible now, sir?
Yes,
You are.
yes.
I'm so sorry. My internet connection shows unstable. I'll just switch off my camera for better transmission. So this was about the penal measures. And another significant aspect of this law, which would be particularly interesting for practicing professionals, not only into this field, into this new field of law, but also in any field of law, and also the company secretaries, is the fact that the legitimate purpose or the usage of data, which is given in section 7 of this law, the principle on which the usage is allowed is this, that the data fiduciary may use, collect, and process the data for all legitimate purposes for any legitimate purposes unless expressly forbidden by a law. This must have been known to everyone, as it is a very general principle taught to us in the foundational years of the profession, that anything which is not expressly forbidden by the law is allowed. However, in my reading, I have seen this first piece of legislation which proceeds and includes this statement of principle in the law itself. And section 7, if you see, it says certain legitimate uses where the use of personal digital data is prescribed in the legislation. There is a little ambiguity, and I must say some problem in the language, but that problem is not so severe that it can't be reconstructed. The problem is this, that section says that certain legitimate uses, which means they are only indicating what could be the legitimate use. Now, section start with the expression that a data fiduciary may process personal data of a data principal for any of the following uses, namely. So it says namely, which is a restrictive term. But then again, the subclauses, I will read one or two, and you would see the subclauses again make it easy to decipher this problem, because the subclauses are couched in the broadest manner possible. Let's for example, subclause A, it says for the specified purpose for which the data principal has voluntarily provided her personal data to the data fiduciary, and in respect of which she has not indicated to the data fiduciary that she does not consent to the use of her personal data. Then for the state, and this is subclause B, for the state and any of its instrumentalities to provide or issue to the data principal such subsidy, benefit, service, certificate, license, or permit as may be prescribed, where she has previously consented to the processing of her personal data by the state or any of its instrumentalities for any subsidy, benefit, service, certificate, license, or permit, or such personal data is available in digital form, in or in non-digital form, and digitized subsequently from any database, register, book, or other document which is maintained by the state or any of its instrumentalities and is notified by the central government, subject to the standards followed for processing, being in accordance with policy issued by central government or any law for the time being in force for governance of personal data. So if you see all these, all the subsequent clauses are also very broad. So therefore, given the definition of, given the remit of legitimate use in section 7, read with the principle that I said is couched in the language of this act, which is that legitimate, you may, the data fiduciary may use or process a digital personal data for all legitimate purposes unless until it is forbidden expressly. It harmonizes into an interpretation that would enable processing of personal data in all manners possible, obviously subject to the procedures recognized by the legislation. And the only fetter would be that something is expressly forbidden. So therefore, this law is not a peremptory law. This is a facilitating law. This only seeks to draw the rules, the broad rules of the game. And it does not, in its strict sense, set boundaries of how far the uses can go. These are left open because data is future. Therefore, this law has been drafted in a manner that the boundaries of usage are not defined exhaustively, but only indicatively, with the principle that if it is forbidden under the law expressly, it can't be used, or the data cannot be processed for that purpose or usage. Apart from this, there are exemptions from this legislation, and those exemptions, before I speak of those exemptions, let me embark on what are the principles that become imperative for keeping such exemptions or keeping such exceptions in this provision. So again, taking you back to the judgment or the case of K.S. Puttaswamy, where right to privacy was recognized. This right, akin to the right and freedom of speech and expression, is also not free from fetters or constraints. The right to privacy, if it is coming in the way of essential state functions of a sovereign, has to give way to those essential state functions. And the commonsensical approach, which is adopted by the courts, is to also apply the Benthamite principle to see the periphery of this right to privacy, that how far it goes, or how far it can travel, or how far one can take immunity in the name of privacy. So therefore, if the question is of public peace, national security, sovereignty of the country, or essential state functions such as investigation, provision of subsidies, working for the welfare of people, then these set of privacy rights, or I must say, in the various subsets of this right to privacy, has to give way so far as those essential state functions are concerned. I'll just quote example. The exemption would apply to investigation of offenses, enforcement of legal rights or claims, and an omnibus.
Ravi, can you hold for a sec?
Yes.
I think the recording has stopped. I heard this message. Shivam, can you see what happened?
Yes.
Anyone from the technical team?
Shivam? Are you there, Shivam?
Yes. Anjali ma'am can see, because Anjali ma'am, you have to check for the recording. You are the host now. Just give me a sec. Let me check with her.
Sorry, Ankit, you said something.
I think you need to, the recording has stopped. You need to start it again.
Just a minute.
I just had a word with the coordinator. They're telling me that the recording is going on offline.
Okay, but there was just a message. Okay, you can continue then.
Continue, Ravi. Continue.
I'm so sorry. So therefore, the an omnibus power is also reserved by the government to exempt certain activities from application of the bill by notification, of this act by notification. And in case of processing by certain government activities in the interest of security of the state and public order, as I said broadly, those are the principles, or for the purpose of research, archiving, or statistical purposes, which could be well for the welfare, or collecting empirical data, such as census, or other essential functions that a government has to discharge. In those functions, this certainly the right to privacy cannot come as a hurdle. So therefore, these exemptions are envisaged. Data Protection Board of India is the regulator which would be created or is created, established by this statute for monitoring the compliance and imposing penalties, directing data fiduciaries to take necessary measures in the event of a data breach. And they can also conduct hearing if grievances are made by affected persons. Board members will be appointed for 2 years and they will be eligible for reappointment. The cadre from where the board members will be coming, it would be from the administrative services, but the relevant qualifications are laid down in the law itself. And the appellate authority is STD-SAT, which is also for the telecom dispute cases. And that authority is the appellate authority. An appeal can be moved within 60 days of a decision rendered by the board. And the penalties, as I stated, are really harsh. They are really deterring. But as I said in the beginning, that this law poses more questions than the answers. There are several issues that are open under this law. Because you do not know how the consents will be obtained. Usually, when you avail a service from a business, and it's a sizable business, these are click and wrap agreements through which consents are obtained. So we need to see how those agreements and how flexible the consent mechanism would be. And I believe the true purpose of the act will only be served, one, if the citizenry takes the responsibility of informing themselves to the usage or processing that is done with their data. They become little data conscious as they are, as we are calorie conscious. I think it is time to become data conscious. Also, equal important role will be played by the transparency shown by the data fiduciaries by way of disclosures and honest descriptions of the processing and usage given to the data principals. But given the and I must say it in all fairness, given the little rate of literacy in technology or technological aspects into common men and women, including professionals, because I might also, and I can say with all reasonableness that I cannot figure out for the apps I have in my mobile or the applications or services I use on daily basis from various providers, that what data they are consuming or they could consume. I might have broad indications, but I do not know. So one has to be inquisitive and know that what data you share while you avail a service through these data fiduciaries. And then the key lies in enforcement. The challenge, the key of implementation lies in the enforcement of this legislation. The legislation is itself broad. It is for the type of subject it deals with. It had to be broad, and it is broad. Even the provisions are very broad-based. And therefore, it will be seen in the course of implementation how those questions will be answered by the Parliament by way of subsequent amendments to the law and by the courts on the issues that will travel to them. Few of the issues I will put up. The one I said regarding the availing and giving of consent. what would be the frequency of consent? What if data is collected and shared offshore thereafter? And from there, the data is shared to somewhere else, because data is a commodity now, which is being sold and exchanged for price, for value of money. And in future, it would be perhaps one of the most valuable assets that is going to exist in the world. So therefore, these are the challenges. Although the act, or although the legislation has provision that government may specify certain jurisdictions, certain countries where the data can't be shared, but how about, and what about if the data is routed or bypassed through jurisdictions where it can be shared currently, but those jurisdictions do not have enough safeguards to protect the personal data there, or if the leakage occurs from there? I mean, all in all, it's a welcome step, because we were governed by 43A so far, which was not a complete code in itself. Now we have a piece of legislation. So definitely the move is in the right direction. We will see these questions being answered as we go forward with the implementation of the law. For now, I think given the timelines and given the structure of program, I could have dealt with these aspects. I would request audience to raise any particular question out of the aspects I have covered. Even beyond these, if there is any query or question, we would benefit from the same. And we would like to take up and discuss in the Q&A part. Moving on to the case laws that has come in the securities law regime and the developments. One is that SEBI has clarified the online dispute resolution framework, being the, I think, one of the first regulators in India to take dispute resolutions online. Although it is in most part of the world, this is only a concept which is being discussed or debated. SEBI has implemented it. They have clarified that the ODR process will not be availed directly if any investor has any grievance. That investor will have to first lodge a complaint directly with the concerned market participant. Thereafter, it can be escalated to SCORES portal. And after utilizing and exhausting these two remedies, then the complaint can be lodged with the ODR, into the ODR mechanism, and it will be taken up there. In short and substance, this ODR is nothing but an arbitration, an online arbitration. So therefore, the rules of arbitration are applicable to this. The framework is built on the architecture of Arbitration Act. And therefore, it will have its own sanctity. And technology has been used to select the arbitrators or conciliators in a manner that they would not have any conflict of interest in the situation. That will be ensured through the processes that are already put in place by SEBI. The second of the circular is by SEBI again to reduce the time limit for alternate investment funds, venture capitals to invest overseas. The timeline was earlier 6 months. These AIFs and VCs could invest into offshore funds or overseas within 6 months from the date of approval. Now that timeline has been reduced to 4 months. And the rationale is the major macroeconomic conditions and the impact of the timelines to make such investments being on these macroeconomic factors. So the decision was taken by a high-level committee, which is also called as Alternative Investments Policy Advisory Committee. Timeline has been shortened so that the investments are, implemented in a streamlined way without giving a lot of margin of time. And because it was felt that investment can be deployed if the regulatory approval process is triggered, there is no reason to keep it for 6 months. But I feel this could be a short-term measure, considering when these indicators or factors change, when the interplay between those factors change, the timeline can be revised again. So there is without much ado, I would move to the cases that have come from SEBI or from SAT since 4th August 2023. And I'm only picking up those cases which I have found to be deciding on some unique aspects of the law. Maybe not for the first time, but these are unique enough to be discussed with all of you. So first, as you see on your screen, is Shiv Darshan Sales Private Limited versus SEBI. There are multiple parties in this matter. And the decision was rendered on 28th of August 2023. What happened in this matter was there was a case of investigation into the scrip of PMC FinCorp Limited, and 62 entities were involved in the investigation. The case was a classic case of fraud alleged by SEBI, that these entities working in cahoots, they rigged the price as well as volume of the scrip during the investigation period. The investigation period was, in fact, quite old. It was pertaining to 2012 to 2015. So you see there are two peculiarities in this matter. The investigation period was considered for long 3 years, and the case was initiated after 7-8 years. The matter was old, which was being investigated. And then the allegations were that price of scrip was raised or rigged by 45.76%. And the appellants were the net buyers, those who bought. Even the prices were going high. The scrip market was on a rally. These appellants were continuously buying, and they posed significant contribution to the positive last traded price and created artificial demand. On these allegations, the charges of market manipulations were leveled by SEBI. For those who have heard this term LTP or last traded price, I must explain that whenever you put an order above the last traded price, that is considered to have a positive impact on the last traded price if the trade goes on, and your quoted price becomes the new price on which the securities are being traded now. So that impact is called as positive impact on the last traded price brought by you. Now, in this case, what the appellate tribunal observed is that the connections drawn between these entities were not cogent. They were not having any nexus with the alleged fraud. SEBI had failed to showcase that. And then the appellate tribunal also recognized, which is a cherished principle, is that buying at increasing prices in a market which is bullish is no crime. Because the yardstick of deciding whether you acted in a fraudulent manner is whether your action had an economic rationale or not. Someone selling at continuous losses, despite there being opportunities of making profit in the market, can be safely called to be committing fraud, because there would be no economic rationale in selling your assets at continuous loss. unless, of course, there is some other scheme of manipulation that is at play. I would not sell something repetitively and indiscriminately, which I had bought at 100, for example, at 1 rupees, thereby each time suffering a loss of 99. And each time the other person is making a profit with the same person. This is a situation which seemingly looks fraudulent. And that was the case in a lot of illiquid stock options case. But here the appellate tribunal says, and it reflects on a fundamental principle of the market, that if I feel, or if in my perception a scrip is going to fare well in the future, based on the fundamentals or technicals or the news that is spreading in the market, if I buy those scripts, even the prices are increasing, because my views are affirmed by the increasing prices. So therefore, my buying into the script more and more has got nothing to do necessarily with the fraud. I could be a genuine investor interested in the script. Then they said nothing on record to show that the appellants placed buy orders above LTP, last traded price. Then the linchpin of SEBI's charge was that all this was done to provide exit to some large shareholders. No details of such shareholders were provided. So therefore, the motive which was alleged by SEBI was held to be presumptive. And thus, in absence of any cogent motive, well, here the SAT remarked about the hypothesis that was built by SEBI, because this was a case weaved on preponderance of probabilities. And SAT observed that because the hypothesis is not cogent, therefore the charges of fraud lack requisite inquiry and therefore are quashed, because this was a final order. In fact, it was a team of corporate professionals that represented appellants in this matter. Then there is a case of Sanjay Kumar versus SEBI. The decision was rendered on 5th of September 2023. The script which was being examined was Sulabh Engineers and Services Limited. And this is an old case where previously also orders were passed by SEBI, both by a whole-time member of SEBI and the adjudicating officer, and the set of orders were quashed. Some were quashed and some were remanded back, and some were upheld by the order of April 2022 passed by SAT. So set of appeals were filed, some of them were quashed, orders were quashed against the decision. The decision of SEBI were quashed, and the cases were remanded back to SEBI for fresh decision. Now this time the decision was rendered by a chief general manager and thereafter by an adjudicating officer. So this chronology would be important for us to understand. In the earlier set of appeals, orders challenged were of whole-time member and adjudicating officer. Both of them had held that these people have committed fraud. These people who were appellants, they challenged the orders in appeal. SAT found that we feel that these should be re-examined or a fresh decision should be taken. So remands back these cases in April 2022 to SEBI. Now, the power of whole-time member is now delegated to a chief general manager. And the adjudicating officer is again examining these matters. What happens now is that chief general manager does not find these people guilty of fraud, and therefore imposes no banning on them. But the adjudicating officer hands out an order penalizing them for fraud. And in this context, these appeals are filed to SAT. SAT looks at the case, discusses in it order that runs into a lot of pages. But there is a para number 20, where they have remarked a fundamental principle on which this case has been decided against SEBI and in the favor of appellants. SAT remarked that when the CGM, which is above the adjudicating officer in hierarchy, and who was also discharging a quasi-judicial function under the delegation of powers by the whole-time members, therefore passing directions under Section 11, has found these person non-guilty. Therefore, how can an AO impose penalty on these people on the same set of facts? Therefore, the SAT said SEBI should have taken a consistent stand. And on the principle of hierarchy, because a higher official has decided that these people have not done fraud, they exonerated them. Another aspect was that in this case, a lot of classification was done. People in the closest ring of fraudulent scheme were the preferential allottees. And then thereafter, there were some there were other investors, other people, TPs, net buyers, net sellers, all these kind of categories were made in the order. But the preferential allottees, the persons who were under the category of preferential allottees, they were sought to be called the kingpin or the main element of the fraud. So SAT said that when SEBI exonerated this main element, this key element of fraud, they could have not possibly charged others who are similarly situated or into a far-flung rung with these charges. So they said parity should have been extended. If those preferential allottees were exonerated, the same parity should have extended to these appellants as well. Then there is case of Pinnacle Market Investment Advisory. The decision was rendered on 6th of September. Here, another important facet has been decided by the SAT. The violations were concerning Investment Advisors Regulations 2013 and Fraudulent and Unfair Trade Practices Regulations 2003. The charges were that the investment advisor had not complied with several prescriptions of law relating to disclosures and charging of fees from the client. They were also providing assured returns to the investors. And as per the record relied on by SEBI, they had also failed to address or redress the investor grievances. However, again, a peculiar thing happened here is that for these allegations, charges of fraud were also leveled on the investment advisor. So SAT, while upholding the penalties imposed on these appellants under the investment advisor regulations, finding that yes, there were violations on their part, found that the charges of fraud could not be sustained because the charges of fraud are odious and cannot be leveled with casualness. A deeper examination and investigation and scrutiny of facts and records is required before a charge of fraud is leveled. And SAT also said that there is no logic that if a violation of some other provision of law is alleged, then the charges of fraud will also automatically attract. Thereby, the charges of fraud have to stand on their independent legs, and a mere violation of some other provision would not automatically attract the charges of fraud. The last one is in the case of V. Manikandan versus adjudicating officer, again rendered on 6th of September 2023. The allegations are pertaining to GDR fraud. As you know, between 2003 to 2010, under the scheme of framed by Ministry of Finance in collaboration with RBI, several Indian companies had brought out GDR and the case should be befittingly called GDR round-tripping fraud, where SEBI, with conclusive evidence, could prove that money was in fact round-tripped and no fresh infusion of capital was brought in. And the matter has traveled up to Supreme Court in the case of Pan Asia Advisors. Professionals would have heard name, those who have followed updates regarding securities law, particularly the orders of SEBI and SAT, they would have heard name of Mr. Arun Pancharia, who was alleged to be the key person behind this entire fraud. And so the case was this, that there was no real subscription. The money was borrowed from the bank. It was kept in collateral on behalf of the investor, who was the sole subscriber for the GDR issue. And that's how. It means I took a loan, and that loan I showcased to my Indian investor that this is the capital I am raising from the investors, while it is a loan in all its sense. So SEBI said it's a fraud. But here the issue was a little peculiar. Mr. V. Manikandan was one of the members of an audit committee of such a company who had brought a GDR issue. And in the order, SEBI had penalized him and also passed directions to him. His case before SAT was this, that when the proposal was not brought before audit committee and when before the 2013 Act, the audit committee was not empowered with such essential functions or such statutory functions as was empowered in 2013 Act, which was the functions were made mandatory. Therefore, to say that because of merely being a member of audit committee, I was liable for this fraud will be a bad statement in law. And the SAT found favor with this argument. They said, yes, he had no role otherwise in the fraud. The material that SEBI has collated does not showcase any role, does not ascribe or explain any role played by this gentleman in the fraud. And the ground is that because he was the member of audit committee, he is charged with the fraud and punished for that. Therefore, SAT distinguished the responsibilities of audit committee members as exists after 1st April 2013, when the New Companies Act 2013 was promulgated a decade back, and the period that operated before Section 177 came into effect. So therefore, SAT has given a prospective effect in other way to the provisions of Section 177 and exonerated Mr. V. Manikandan from the heat of penalties and directions imposed by SEBI. That was all from my side for today, sir.
Thank you. Thank you very much, Ravi, for taking us through the very important law on digital protection, personal data, and also taking us through very important judgments or orders of SAT. Thank you very much. I think there are no questions to the panelists. So in my closing remarks, I will only say that as far as the Digital Personal Data Protection Act is concerned, there are two features I find very distinctive and very redeeming. One is that this law has been written in very simple language. This is unlike the usual couching the various sections and provisions in a very legal language. So this is very differently written law. Secondly, I find that in place of he, throughout the act, the word she has been used. So it is her oblique him, not him oblique her. And to get the clear implications of the bill, let us wait for all the prescriptions. There are various prescriptions under the Act. So let us wait for the rules and the various notifications to understand the nuances of the Act. Friends, thank you very much. I must thank all the learned panelists for sparing their valuable time in sharing insights into the various regulatory and legal updates. Friends, our journey of sharing knowledge will continue, and our 145th webinar will be held on 15th of September 2023 from 4 p.m. to 6 p.m. on a very important topic, that is, we will discuss valuation in the next webinar. In the meantime, thank you very much for joining us in large numbers, and thank you once again all the learned panelists. Thank you very much.
Thank you, sir. Thanks, everyone.
Thank you.